Today is fixed for the defence motion for judgment of acquittal pursuant to Rule 98.
Mr. President, as you've indicated, we are here pursuant to Rule 98 of the Special Court Rules of Procedure and Evidence. And we are here to move the court respectfully in our submission to dismiss each and every count of the second amended indictment against the accused Charles Yankee Taylor. So the prosecution is telling us in the amended case summary that this common plan did not change. This common plan that spans from 1988 until 2002 did not change. The alleged meeting of the minds that Charles Taylor had with Fode Sanko in 1998, its sum and substance, its core, its purpose, did not change. There were no mutations between 1988 and 2002. That means the evidence should bear this out. Assuming for the sake of argument that whatever common plan they have alleged is a crime, then the evidence must bear out that the common plan remained one and the same. Assuming in the first instance there was a common plan. Let us consider some of the evidence that has been presented. Generally, we know Fode Sanko was imprisoned, as I've mentioned previously, from 1997, I believe the evidence is March 1997, until his release to attend the Lome Peace Accord on or about in April of 1999. There has been evidence that Fode Sanko and Sam Bokary had a dispute while Fode Sanko was in custody. The leader of the RUF, the evidence suggests or confirms, was in prison. He is the one with whom it is alleged Charles Taylor had this meeting of the minds. What evidence is there to suggest that Charles Taylor and Sam Bokary, who assumed the leadership of the RUF, had a meeting of the minds amounting to the same common purpose that Charles Taylor had with Fode Sanko? Evidence confirms that after Sam Bokary departed for Monrovia on or about the 14th of December 1999, at some point thereafter, Issa Sese took over the leadership of the RUF. That being the case, one has to review the record to find out what evidence suggests that there was a meeting of the mind, that Issa Sese and Charles Taylor were both participants in this common plan, that the plan that existed between Charles Taylor and Fode Sanko, starting as alleged from 1998, manifested itself, or as alleged from 1988, manifested itself in the relationship, if any, between Charles Taylor and Issa Sese. All we are doing, Your Honors, is applying what the law requires, guided by the delineations and scope that the prosecution has pleaded in the indictment. Let us consider the January 6th invasion of Freetown. If the persons who went into Freetown acted with a different intent or acted with a different purpose, how can it be said that Charles Taylor is criminally responsible? The prosecution is obligated to plead a change in the common purpose or plan if one in fact materializes. There are cases where a group of co-perpetrators start out with one intent, and whatever the ultimate objective is, along the course of the way, it changes. It happens all the time in criminal cases. But the defense cannot guess at what this change is. The prosecution has to lead evidence about the changed purposes And here you have the actual forces who go into Freetown on the prosecution's own evidence before this court. Witnesses called by them, some saying that re-establishing or reinstating the Sierra Leone Army was the main reason behind this. Now, there has been evidence also of Sarge Musa and what he instructed his fighters to do or not do during the invasion. This comes from a witness at page 9015 through 9018 of the transcript. The witness says in Colonel Eddy Town, his group met with Sarge Musa, and Sarge Musa ordered them to go to Freetown and overthrow the government without killing, looting, and burning houses. This is the prosecution's own evidence. So on the one hand, the standard of review for Rule 98 asks you to believe this evidence, including what I've just read. On the other hand, it asks you to believe the alleged involvement of Charles Taylor in the January 6th invasion. But the two cannot stand. The two cannot be capable of supporting a conviction. They are contradictory. And this is where the application of the legal principles to the facts becomes important.